This is an appeal in the matter of Abbott Diabetes Care and others, and Dexcom and others.
Yes, Mr Abrams.
My Lords, I appear with Ms Dixon for Abbott, who in this appeal challenged paragraph 1 of Mr Justice Mellor's order of 13th of January 2025, which revoked 2 patents owned by Abbott's. And your Lordships will have seen from the papers that although my clients are settled against Dexcom, the other party of the proceedings, Lord Justice Arnold granted my client's permission to appeal and requested the controller to appear to present counter-arguments, and that Dr Barron appears for the controller in that capacity. Just for completeness, paragraph 1 of the order of 13th of January was consequent on a trial in late 2022 and judgment handed down in January 2024. We call that trial A. And that order also contained provisions relating to trials B and C, and this court's going to hear an appeal in relation to trial B next month.
Right. Okay, thank you. I can tell you, Mr Abrams, we've read the papers, and thank you very much for the skeletons and the judgment and the patents. I'm bound to say, at the moment, it seems unlikely that this case should require 2 days to hear.
Certainly not 2 full days.
No. Why a second day at all?
Okay, I will do my very best then.
Points of construction, basically, with a bit of fact at the end. Doesn't feel like a 2-day case. Feels like a 1-day case.
I can see why you say that. I'll do my very best to go quickly enough so that my learned friend can also make points he wants to make.
Quite so. Right.
As your Lordship says, all the points are points of construction of the 2 patents and a couple of points of construction of one of the pieces of prior art. No issues on the skilled person, the common general knowledge, no challenge to any finding of fact, no challenge to any evaluative determination, which obviously makes my job easier since the points are all essentially points of law. To further simplify matters, we're only asking this court to consider claim 1 of each patent. Now, my Lords, I can make all my submissions on both patents before sitting down, but your Lordships have the option of hearing each of us on the 627 patent and then hearing each of us on the 223 patent.
Well, subject to my Lords, I think let's just hear everything you have to say on both of them, Mr Abrams.
Fine. And I'm going to follow the structure of my skeleton argument. So in terms of the legal topics, I can be very brief. There are 3 issues. First is the construction of patents, and here Dr Barron and I agree that the relevant principles are set out in paragraphs 18 and 19 of the Saab CI case, which is in the authorities bundle, and which requires no elaboration from either of us. Second, there's the test for anticipation, and here Dr Barron and I agree on the strictness of the test. His skeleton argument very helpfully cites and quotes from the relevant authorities, and as he makes clear, and we agree, it requires clear and unambiguous disclosure of something falling within the claim, or instructions to do something falling within the claim. It doesn't include things which would occur to the skilled reader, but which are not actually disclosed in the document. And then there's a third point of law on which we might disagree. That's the role of expert evidence in the context of anticipation and construing the prior art. That point arises in the context of ground 3 of the 223 patent, and it's more convenient to address it there. I should also mention the delay between the trial and the judge's judgment, some 13 months, which Lord Justice Arnold described as inordinate when granting permission to appeal. That sort of delay is highly material when the grounds of appeal challenge an evaluative determination, not this case. But it's still a matter which your Lordships will bear in mind when considering the judge's judgment. There is at least one point in the judgment where the judge appears to have forgotten to deal with a point, and that may have been a result of the delay in writing the judgment. Okay. So, my Lord, it's useful for me to do some brief technical background, and it's convenient to do that from the judgment just to show you the relevant points in the judgment. So that's the core bundle tab 6. And I'll use the the bundle page numbers in the bottom right-hand corner of the bundles. So, starting on page 68, paragraph 2, the judge records that CGM devices, continuous glucose monitoring devices, are used by diabetic patients for the purpose of monitoring their blood glucose with a view of taking action if their blood glucose becomes too high, hyperglycemia, that requires an injection of insulin, or too low, hypoglycemia, requiring consumption of carbohydrates. Diabetes as a disease is described in the section starting at paragraph 22, and paragraph 24 is the useful summary for your lordships to read. And as noted is at paragraph 25, sub 1, many diabetic patients require injections of synthetic insulin to be able to control their blood glucose levels. Now, diabetes in its management gives rise to two serious conditions, which we've just seen mentioned in paragraph 2. The first is hyperglycemia, high blood sugar, and that's described at paragraph 31. And as the judge explained, effects here include feeling weak or tired, diabetic ketoacidosis, which is a life-threatening condition, and long-term effects such as vascular complications. So that's hyperglycemia. And secondly, hypoglycemia, low blood sugar, that's referred to in 32. That's a serious side effect of insulin therapy, and it arises when excess insulin causes the blood sugar to drop to dangerous levels, and it's the leading cause of death in people with diabetes under the age of 40. And as the judge said at the end of, just going back to paragraph 26 on the previous page, the primary objective of type 1 diabetes self-management is to prevent immediate adverse glycemic events. Essentially, the patient is walking a tightrope between high glucose.
You were reading from somewhere.
Sorry, end of 26. Sorry,
End of 26.
last sentence of 26.
Primary objective, thank you.
It talks about the tightrope between hyper and hypoglycemia. And it's in that context, that tightrope, that CGM devices are extremely valuable. And the judge addressed CGM devices starting at 45 and over the page onto paragraph 46. Please could you read paragraph 46?
So there's a sensor that goes against your skin and a little transmitter that goes to a little thing like a pager that you could wear.
The sensor goes under the skin into the subcutaneous tissue. It's connected to the transmitter, as you say, and then that transmits wirelessly at the priority date to a device here called a monitor in the picture, but more usually called a receiver or a reader, and that's the term I'm going to use. And by way of illustration, on page 87, you can see the latest Dexcom reader around the priority date of 627. That's what it looked like. And then if you just flip over to 89, this is a slightly later reader, but not materially different. And the reason for looking at this is it's labelled to show the wealth of information which the reader provides to the user. And that includes, as you can see, a graph showing historical blood glucose levels. So the user can see how well they've managed their glucose over the previous period of time, day or week or whatever, as well as the current level. And these CGM systems were a significant improvement on the previous method of self-monitoring of blood glucose, which involved pricking one's finger to draw blood, followed by testing the blood in a portable blood glucose meter, BGM. And that's obviously painful, it's inconvenient, and it's intermittent, whereas a CGM is painless once you've inserted the filament under your skin, and it's convenient, and it provides a continuous measurement of glucose levels. Now, a key feature of all the CGMs by the priority date was the provision of indicators of hypoglycemia and hyperglycemia via notifications, typically known as alerts or alarms. And this is addressed in the judgment starting at paragraph 50. And it would be worth your lordship's reading 50. Excuse me? 50. 50, 50. It would be worth your lordship's reading paragraphs 50 to 53.
This is this distinction between alarms and alerts, which the two parties use differently.
Yes, and not necessary for your lordships to worry about. You can treat them as synonyms. It was relevant for a different patent, which is not before this court. Then at paragraph 59, the judge refers to a feature of all the CGMs by the priority date, which is the ability to look not just at current glucose levels, but at the user's blood glucose history and trends. And we saw that on the reader. You can see it was displayed in the form of a graph. And paragraph 59 explains the usefulness of that for self-management. Then, starting at paragraph 67, the judge went on to review the commercially available CGM devices in some detail, and the only point that's necessary to take from that is just there was a wealth of features which the state-of-the-art devices provided to users. And that provides the context for the 627 patent, which I'm now turning to. In my skeleton argument, I'm now on page 18 of the skeleton in the bundle. But I'm going to go to, if I can go to the 627 patent, which is in the supplementary bundle at tab 1. So this patent is addressed to a designer of medical devices whom the judge described in his judgment at paragraph 139. 627 describes various aspects of a CGM system, but claims only a subset of the functionality disclosed. So obviously I'm going to focus on the relevant subset of functionality disclosed in this document. Now, as I said, the context for this invention is the wealth of features that CGM devices at the priority date provided to users. So,
the priority, sorry, just to be clear, the priority date is 2007.
Correct.
The day and the month don't matter.
Correct.
And we read it as if we are persons skilled in the art in 2007.
Thank you, my lord. Yes. At that date, CGM devices were providing more and more features for users. So in addition to a user simply seeing what their current blood glucose level was, they might be interacting with their reader to review historical data or to change alarm settings or indeed other settings, so on. And the invention of 627 is a way of dealing with alarms that occur while the user is doing that sort of thing. So on the one hand, if the user is reviewing their historical data, they might not want that exercise to be disrupted by an alarm. But on the other hand, these are important alerts, and you do not want users to ignore them or forget them because they're busy with their settings, for example. So the inventiveness of 627 lies both in identifying that issue as something to be addressed and in the particular solution. And the solution that's claimed is illustrated in figure 10, which is on page 29 of the bundle. So at box 1010, the predetermined routine begins. Now the predetermined routine, or PDR, as we call it at trial and in the judgment, is what the patent uses to call the activity that the user is doing on their device, such as looking at historical data or whatever. And we'll come back to the issue of construction of that term. Then the PDR continues throughout this until it's terminated in box 1040 near the end. During the execution of the PDR, if an alarm condition is detected in box 1020, the user is notified by a first indication during the execution of the PDR. That's box 1030. And as we'll see, the key point of the first notification is that it doesn't disrupt or interrupt the ongoing routine. And then when the user is finished with the PDR in box 1040, a second indication associated with a detected alarm condition is output or displayed. So you have this advantageous combination of two notifications. First, the immediate alarm condition, but in a gentle way which doesn't disrupt or disrupt what they're doing or require them to stop what they're doing. And then second, there's a follow-up notification when the user's finished doing whatever it is that they were doing. Now, this figure is described in a passage in the patent which is very important for the appeal, on page 12 of the bundle. It's paragraph 77 to 81. Can I ask your lordships to read that? And then I'll identify 6 important points in that passage.
So you want us to read
77 to 81, please. So my 6 points are these. First, paragraph 80 describes the PDR, and as I said, it's the activities that the user could be doing on their CGM reader, such as consulting historical data. And they're capable of being interrupted by an alert that, for example, blood glucose has dropped below a certain level. But nevertheless, the user might want to finish before turning to deal with that alert. Second, the first notification is provided in real time, i.e. more or less immediately. That's paragraph 79, line 12. Third, the key point of the first notification is that it does not disrupt what the user is doing on the device, and that point is made at least 3 times in this passage in each of paragraphs 78, 79 and 81. Fourth, the second notification is provided upon completion of the PDR. You get that at the end of 78 and in 79. And so the purpose of this notification is that if the user ignored the first notification because they were busy with doing something on their CGM reader, then at this stage they'll be re-notified of the detected condition and will now hopefully do something about it. The fifth point is this. It's clear from this passage that the detection of the condition and the notification of the condition is something separate from and outside the PDR. You get this especially from paragraph 79, as well as the repeated emphasis on the first notification not interrupting or disrupting the PDR. That tells you that the first notification is coming from outside the PDR. And the sixth point is that both notifications are notifications of the same detected alarm condition, and that's most clearly spelt out in paragraph 78. So one detection of one condition resulting in 2 notifications.
So which bit of 78, sorry, I may be looking at the wrong. Which line of 78 are you talking about?
I think you said 79.
So it's, did I, sorry, so I did say 78. Yes, it's 78. 78, the first sentence of 78 describes the first condition, sorry, the first notification. And then in the second sentence it says, upon determination of the predetermined routine, another output or second indication associated with the detected alarm condition is output or displayed.
So which line is the word another? Oh, there it is there, 55.
55.
Upon termination of a predetermined routine, another output
Of the
associated with the detected
alarm condition.
I see. Yeah, thank you. Okay.
At that point, common ground is a matter of construction of the claim. We're coming to that now. So claim 1 is set out in our skeleton argument, broken down in integers, which is a convenient way to look at it. So that's core bundle, tab 2, page 20. Together, and we've commented on it in paragraph 24. So your lordships can see that the PDR is defined in integers 1.1 and 1.9. And per integer 1.9, it's something which interfaces with the user interface of the device, i.e. it's the sort of routine which we saw described in the patent at paragraph 80. And the alarm condition is detected in integer 1.2. And then the first indication is described in integers 1.3 and 1.7. And this is the gentle alert that's output during the PDR, but which doesn't interrupt it or disrupt what the user is doing. And then the second indication is provided for in integers 1.4, 1.5, and 1.8. And importantly, that second notification is associated with the same detected predetermined alarm condition as the first indication. That's apparent from the use of the definite article in integers 1.3, 1.4, 1.8, as well as the context, which we've seen from the specification. So it was common ground at trial and accepted by the judge in the judgment that there's one detected alarm condition to which the first and second indications both relate. My lords, there's a typo in our skeleton argument, I'm afraid, at paragraph 24E, where it says the first indication, that should be the second indication.
Sorry, 24B.
E, my lord. It says the first indication, that's the second indication. So, my lord, that's the claim. And now I turn to the prior art. So in our skeleton argument, I'm on paragraph 25. And the prior art is called the STS Guide, and it's in the supplementary bundle, tab 3. This is the user guide for Dexcom's STS CGM device. And the relevant functionality for this appeal is on page 114 of the bundle.
So as I understand it, Mr. Raven, just get ourselves oriented. This document is the thing which you are relying on as the prior art. In other words, what legally is relevant is what was made available to the public before the date.
Correct.
Although it's a description of an object, it's the document which is what matters.
That's correct. But obviously, not Dexcom were relying on.
Forgive me, Dexcom.
Yes, correct. It is the document that was relying on.
Okay.
So if you're on page 114, this has a section 5.1.1. Now, to understand this, you need to know that the sensor for use with this device had a 3-day lifespan. And that lifespan is referred to in the document as the continuous glucose monitoring session, or CGM session. So for our purposes, the CGM session is simply the 3-day lifespan of the sensor. So with that in mind, the document says your STS receiver will notify you how much time you have remaining until your STS continuous glucose monitoring session is complete. The expiration screen will simply appear 6 hours and 2 hours before your 72-hour session ends. At the 30-minute and 0-hour expiration screen, the STS receiver will display the expiration screen and will also vibrate. You can clear all of these screens by pressing any button on the STS receiver. You can remove your STS sensor when the 0-hour screen appears. And then those 4 screens are shown below. And note also, for the last 2, you get plus vibration.
Is there a reason why there are 3 pictures?
Yes, they're animated.
Oh, I see.
So those are ever so slightly different
I-
stills, if you like, of the animation. Took me quite a while to work that out. Just for completeness, the screens with descriptions are also shown on page 93 of the bundle, but you don't get any relevant information from that page. Page 93 is cut and pasted into the judgment, but contains nothing more than we've already seen. So the case at trial was that the STS guide, the document as a document, anticipated the 67 patent. No separate case of obviousness was run. And the relevant part of the judgment is in the core bundle. So that's tab 6 of the core bundle at page 109.
Just so I understand that, those signals just come up automatically.
Yes, they just appear on the screen. It uses the words "will simply appear," and then the 2 with 30 minutes to go, there'll also be a vibration, and then at 0 hour there'll also be a vibration.
And presumably, and they will appear whatever you're doing. You may not be doing anything, or you may be doing something.
Correct. So at so I'm on page 109 of the core bundle, at paragraph 202. And so what the judge does is he first sets out Dexcom's case, and then at 215 he says he accepts that case. So 203 to 210 represent the anticipation finding that I'm appealing against. So I'd invite you to read those paragraphs.
I see. So what's happening here is the judge is using the bits of the claim, the integers, as headings, and,
Yes.
then writing a bit of judgment, as it were, in each paragraph,
Yes,
which relates the STS guide to what's claimed.
correct. Then He then considers Abbott's arguments, rejects them, and concludes that the analysis that I've just invited you to read is correct. So my client's appeal against that analysis on the basis of two grounds, which we've called 1A and 1B, and only need to succeed on one of those grounds to overturn the finding of anticipation. Both grounds focus on the construction of Claim 1, and both grounds arise from the fact that the judge's conclusion can't really be reconciled with the purpose of construction of Claim 1. We've seen what the purpose of the claimed method is, to allow the user to continue executing a PDR uninterrupted, but then be re-notified at the end. This functionality that I've shown you has nothing to do with the functionality claimed in Claim 1 of 627.
Does the claim say that the user has to execute the PDR?
No, the user says it says that the PDR has to interface with the user interface. Indeed. Okay. Those are the words of the claim. And my grounds of appeal do take that into account. So ground 1A, and that's really the focus of 1B. The way we put it is put in 1B. But if I can start with 1A, which is addressed in our skeleton argument starting at page 23, and it's a simple point that the 30-minute sensor expiration notification and the 0-hour sensor expiration notification do not relate to the same detected predefined alarm condition. As I said, I may have laboured this and I may be labouring it now. Claim 1 requires detection of one condition, resulting in two notifications, whereas this functionality involves two conditions, each being detected and each resulting in a notification. The condition which is detected with 30 minutes to go is that the CGM session has 30 minutes to go, and the condition which is detected and indicated to the user by the 0-hour notification is that the sensor is actually expired. So there are, so as I say, two different conditions, two separate detections, each with its own notification. And the problem with the judge's approach is manifest from the judgment itself. So if you've still got pages 110 and 111 open, at 204, which in due course he approves, he records that the condition is, quote, impending STS sensor expiration, obviously underlying impending. And then at 214, when he's rejecting the argument, which I'm now putting to your lordships, at the very end of 214, he says that the predefined alarm condition is sensor expiring. And obviously impending expiry is a different condition to it has actually expired. And
isn't that just a paraphrase? Isn't that what the judge is doing in 214?
Well,
sensor expiry to be a paraphrase of the phrase he used earlier. I can't remember what it was now.
Impending. It may be that he's attempting to do a paraphrase, but nevertheless, the difference is he's correct about the difference, and he's correct to use different language because they are different conditions. And what's particularly striking about this analysis is that it overlooks the important word detected, which is repeated throughout the claim. The alarm condition is always described as the detected alarm condition. So that's why we say in the STS guide, the condition that's detected when the 30-minute notification is output is that the session has 30 minutes remaining. The condition is not sensor expiry because the sensor hasn't expired. It's that it's 30 minutes until expiry. And then when
isn't it impending STS expiration?
Yes.
Why isn't it that?
Well, it's particularly 30 minutes because it's already detected. It's already detected. I'm going to get the number of hours wrong. 6 hours, I think.
It's already detected some hours.
It's already yes.
Doesn't matter how many hours they are.
No, indeed. It's already detected 6 hours, and it's already detected 2 hours, and now it's detecting 30 minutes. And in a little bit of time, it's going to detect that it has actually expired. That's 4 detections.
You say those are 4 conditions, and the way the judge has approached it is on the basis that the impending expiry of the thing, which is impending, is one condition.
Indeed. The one edit I would make to your lordship's summary is there are 4 detected conditions.
Right.
Remember, the claim always says detected conditions. My Lord, my learned friend Dr. Barron very attractively presents the counter argument. Can I just make a couple of comments on how he does that in his skeleton argument? So that's on page 43. So 52, he says the alarm condition is one which doesn't change. 54, I think it's fair to say, he's acknowledging some force in what I'm submitting, because there is a difference between will end and has ended. And I've made my submission that the indications are not identical in a literalistic sense or any other sense. They are just different submissions. But there's a more fundamental flaw with my learned friend's line of argument, which is exposed at paragraph 58. So at 58A, he says correctly, at 30 minutes out, at 12:04, the alarm condition that is detected is that the sensor expiry occurs at 12:34. Sensor expiry will occur at 12:34. Then in B, he doesn't include the word detected, but what B should say is that at 12:34, the alarm condition that is detected is that sensor expiry has occurred. And it's the two separate detections being described in paragraph 58, and therefore the two separate detected predefined alarm conditions, which are being described in paragraph 58 by my learned friend. So if you rewrite 58B in the same terms as 58A, you'd see that there are two separate detections, two separate conditions.
Did you read a will into 58A? It's not there, is it?
At 12:05, the alarm condition that is detected is that sensor expiry. What he says occurs at 12:34. I read in will occur at 12:34.
Yeah, no, I understand. I get that you're reading it in. I just thought you were reading it as if it was already there.
Will occur, yes. Occurs, will occur. I think that's probably just a stylistic choice.
Getting back to your point about impending, the judge said that the first alarm is the impending
Yes.
expiry. Is your point that the second alarm can't be an impending expiry because it has expired?
Indeed. So it's both a separate condition, which is what your lordship's putting to me. It's a separate condition. It has expired, not it will expire. It has expired, and there's also must be a separate detection.
Yeah.
There must be some timer and triggering something in the software, and that happens once with 30 minutes out. That's one detection, and again it'll happen some other trigger at 12:34. So that's our ground 1A. Ground 1B is addressed in our skeleton argument starting on page 25. And the point here is that the CGM session described in the SDS guide is not a PDR within the meaning of the claim. So as we've seen, claim 1 specifies that the PDR must include one or more processes that interface with the user interface. That's integer 1.9. And then integer 1.6 specifies that the PDR is not interrupted by the outputting of the first indication. And we saw the examples of PDRs given in the patent at paragraph 80. They're all of this sort. They're all activities that a user could be doing, interacting with their CGM device, which they might wish to finish before turning to deal with an alerted condition. And it's in that sort of case, and only in that sort of case, that the invention of the patent is relevant. So it follows from that the PDR must be a routine of the sort that is capable of being interrupted by a notification, which is output to the user interface. Otherwise, integer 1.6 would be OTS. And it's clear that the CGM session in the SDS guide is not that sort of routine. So first of all, the CGM session is a process that happens automatically, regardless of what is output on the screen and regardless of what else the user is doing with their device. There's no interactive element. The screens simply appear and the vibrations simply occur at the respective times. We saw that in section 5.1.1. So there's no interaction with the user. And although, as my lord, the Chancellor just pointed out, the claim doesn't say that the PDR has to be interacted with the user. If the PDR is not something that's capable of interruption, It's just simply not a PDR of the sort contemplated by this patent. The second point, which is closely related to the first point, is that the only respect in which the CGM session may be said to include one or more processes that interface with the user interface is the output of the sensor expiry notifications themselves. That was how the judge held that integer 1.9 was fulfilled. We saw that at paragraph 210. It's those screens which are the interface with the user interface. But if the 30-minute notification is part of the PDR, then it's nonsensical or circular to say that the execution of the PDR continues without interruption when the first notification occurs, since the first notification is part of the PDR itself. I showed you paragraph 77 and 81 of the patent, which make it clear that the notifications are something separate from and outside the PDR. But the first one, at least, is set up in such a way that it allows the PDR to continue without disruption, despite the first notification being notified to the user. The whole method would be utterly futile if the alarm condition and notification of that condition were part of the normal execution of the PDR. The concept of without disruption is meaningless if the notification is inherent to the PDR. It's like saying that the words of my submissions are not interrupting my submissions. They are my submissions. It's just
Maybe they are, Mr. Abrams.
for better or worse. For better or worse, they are my submissions. And to say that Mr. Abrams is making submissions without interrupting his submissions is just a silly thing to say. But that's the effect of Dexcom's case that the judge accepted. And by way of final comment on this ground, if one looks at it at the level of purposive construction, the whole purpose of 627 is that when the user is doing one thing on their CGM reader, they do not want to be interrupted by an alert caused by something else and interrupting what they're doing. So the user gives them, but they don't want to be interrupted, but nevertheless, this is important, so they do need to be told, and that's why you get the second notification. And the timer functionality described in the STS guide is just not remotely similar to that. So, my lord, those are my submissions on 627. And I'll move to 223.
Yes.
That is addressed in our skeleton argument starting on page 26. So, the priority date of this patent is September 2009. It's addressed to a medical device software engineer or architect whom the judge described in his judgment 250 to 255. And as my lord said, we have to construe the patent through the eyes of such a person reading it in September 2009. My lords, the judge laid out that skilled person's common general knowledge in the section starting at 256. And the key point for the purpose of this appeal is described in a slightly earlier section, which is at 248 to 249. And the point there that he concluded on the evidence is that there was a good deal of interest at the priority date in putting the reader functionality onto an iPhone or other smartphone. So instead of there being a dedicated reader, or perhaps as well as being a dedicated reader, the sensor data would be transmitted to a smartphone, which would have an app on it, which would provide all the functionality of a CGM reader. So
that's the point is you want to use the smartphone as the effect. I'm going to say receiver, but
receiver, that's a regular word.
and the problem with a smartphone is it's not your thing. It's someone else's thing.
Exactly.
You're just taking your place as one of the apps on that.
Exactly.
And you can't control it in the same way that you could if it was your object.
Exactly. And your lordship is obviously on top of the first five paragraphs of the patent, which I was going to show your lordships now.
You better, for the benefit of everybody.
Yes. And me to make sure I've got all the extracted all the juice I can from that passage. So it's the
You
supplement.
didn't say to you that it's only mobile phones.
No, it's not only mobile phones.
So it might include a laptop
Correct.
or even a desktop.
Correct.
Yeah. But a mobile phone would be handy.
That's the paradigm. That's obviously what it's aimed at. That's the paradigm, and it doesn't make any difference to the issues in the appeal if I focus on a mobile phone. So I'm in the supplemental bundle in on page 32. So, paragraph 1 introduces the concept of a safety critical system. So please could you read paragraph 1 or remind your lordships yourselves of paragraph 1. Paragraph 2 references some prior art. We don't need to look at that. Then paragraphs 3 and 4 explain the carefully controlled nature of safety critical systems at the priority date, and paragraphs 3 and 4 are important. The key point being made here is the carefully controlled nature of safety critical systems at the priority date. They're integrated controlled systems in which the manufacturer has complete control over all the hardware and all the software so that they can validate and verify the entire system. That's the first sentence of paragraph 4, before releasing it to the public. And I can't do better than quote the end of paragraph 4. Such a controlled system environment provides a certain level of confidence that the system will not be altered or changed and potentially affects the proper operation of the system. But the problem, as my lord just mentioned, is what if you then put that functionality onto a smartphone or something which you don't have complete control? And that's obviously, as I said, something of which there was a lot of interest at the priority date. All the CGM systems at the priority date were of this sort, these completely controlled systems, but that was something that people were working on. And the problems explained in paragraph 5, just before we read that, paragraph 5 introduces 2 concepts. The first is the uncontrolled data processing device, UDPD, a device which permits users to install software on it. And there are examples given in lines 14 to 16. You see an iPhone or a desktop computer or a laptop, as my lord suggested. The thing they've all got in common is that the user can add different software, different apps, or even different operating systems in the case of desktop computers to them. And those were very common in 2009, of course, running a variety of applications. The second concept that paragraph 5 introduces is the safety critical application, or SCA. So up to now, the patent had been discussing integrated controlled systems. So it used the word system. Now in 5, it's talking about a software application on an uncontrolled device. And for that, it coins the expression safety critical application. So the paradigm case would be for a smartphone, an app downloaded from an app store of some sort. So with that in mind, please read paragraph 5. And I would underline that this is presented as a new problem which this patent is going to address. And paragraph 6 introduces the solution provided by the patent. Please could you read paragraph 6? As it says here, the patent discloses various combinations of checks. Not all of them are claimed in Claim 1, so I'm going to focus on the disclosure relevant to the invention in Claim 1. So the first relevant check is the installation check, and that is described at paragraph 64 on page 39. Your Lordship should see a subheading installation check underlined. And that says, in some aspects of the present disclosure, an installation check may be executed to determine whether the SCA is installed properly on the UDPD. Because an improperly installed SCA compromises any assurance that the SCA is going to operate properly on a UDPD, a successful installation of the SCA may be required in order to determine that SCA operates properly on the UDPD. And then in the rest of 65 and 67, there are some modes of carrying out an installation check to describe some possible modes of doing that. The second relevant check is the functional check, which is at paragraph 68, which starts by saying, in some aspects of the present disclosure, a functional check may be executed to determine whether the SCA functions properly on the UDPD. For example, a functional check may check whether SCA performs computations, e.g. calculations, measurements accurately on the UDPD, whether the SCA displays data properly, and so on and so forth. And then it gives some more detail that's not necessary for the purpose of this appeal in paragraph 69 and 70. Those are the two checks required by Claim 1. Other checks which are described in the patent but are not relevant to this appeal are described from 71 onwards. So just so that you see them, 71 refers to an environment check, 76 host integrity check, 77 coexistence check, interoperability check, and the last one on 83 power management check. A further very important aspect of 223 is the concept which is referred to in the judgment as selective enablement. That concept is introduced in paragraphs 47 and 48, but in fact it's very clearly articulated in Claim 1, so I'm going to pick it up from there, but just for reference, it's described in the specification 47 and 48. So Claim 1 is set out in our skeleton argument, page 27 of the bundle. This is Claim 1 as granted. The judge had before him a conditional amendment. That's not relevant given the way the arguments and the decisions came out, so this is Claim 1 as granted. You can see from the preamble and integer 1.1 that it's about hosting an SCA on an uncontrolled data processing device. So as I said, the paradigm case would be an app on an iPhone. Integer 1.2a requires both an installation check and a functional check, determining whether it's installed properly and functions properly. Now, on reflection, we accept the judge's finding that on the language of this claim, a single check may fulfill both tasks. So I won't be pursuing the argument that two separate checks are required by this claim. That argument was a sub-point under ground 2. Integers 1.2b and 1.2d require what we call selective enablement, which is the subject of ground 3. And what this is saying is that where one of the two checks is failed, or where it's determined that it's not installed properly or functioning properly, the safety critical features of the application are disabled, but the non-safety critical features are enabled. So just spelling that out. There are two limbs of selective enablement. The first limb is in integer 1.2c. The safety critical features are disabled. And the second limb is integer 1.2d. The non-safety critical features are enabled. So we would say the following is an example of selective enablement. If the CGM app on your iPhone was not functioning properly, the provision of real-time blood glucose alarms would be disabled, but the app would still allow you to look at stored historical blood glucose data. That would be disabling of a safety critical feature, but enabling a non-safety critical feature. Now, what this discussion brings out is that the claim requires that the SCA has both safety critical features and non-safety critical features. And that is relevant to the understanding of the expression safety critical, which we're going to come to.
Just a minute. So I'm looking at 1, 2, A, B, C, and D at the moment.
Mm-hmm.
And step, because this is a method, this is a description of a method, not a thing. So 1, 2A, you determine something. You determine whether the thing is installed properly and functions properly. Then 1, 2B says you prevent something, and 1, 2C is a bit of detail, which might be thought to come as part of, and I'm not complaining about the way it's been broken up, I understand that, but it's part of the preventing, wherein the preventing comprises and that is conditional, and the condition is buried in the text in there when it says upon verification that it didn't install properly or doesn't function properly.
Yes.
So you do 1.2B and C if you found that either it's not installed or not functions properly.
Absolutely correct.
But you don't do preventing if it has installed properly.
Correct.
And so on. Whereas 1.2D isn't subject to that condition.
Incorrect.
Incorrect.
Because of that's not your fault. It's because it's the way it's set out. If you look at the claim itself, 1.2C and D is effectively a single paragraph.
1.2C and D.
Yes. So wherein the preventing comprises two things. The preventing comprises first disabling safety critical ... and enabling non-safety critical. So C and D are particulars of B. They're both particulars of B. They're both, I think that's why I think I was right to say your lordship was incorrect.
Okay.
And helpfully my learned friend agrees with that. And I do think that that's an artifact.
It's an odd wording way though, isn't it? Because that means that enabling is part of preventing.
Exactly.
Grammatically.
You're absolutely right. It's some people might call that patentese. Yes, if you go to page 58 of the patent, A, B, C, and D are all one paragraph. And then E is a separate paragraph. And that underlines that C and D are particulars of B. They're particulars of C and D explain what preventing means.
I suppose looking at it on page 58, and it's all the same words, I understand. I can see it that paragraph, as you put it, the one that starts preventing, comma, with the, it does say preventing with the uncontrolled data processing device certain features of the safety critical application.
Exactly.
Operating. So it's clear that when the preventing is only certain features, and then it continues, and in the detail it then says wherein the preventing comprises disabling safety and enabling non-safety.
Yes, exactly. That's exactly the right way to read it, my lord.
All right.
This is a convenient.
Sorry, could I just go back to something you said just before that, when you said that an example of a non-safety critical
feature
might be to do with using the device to download the historical glucose readings on your example. I don't know whether it matters, but it's not obvious to me that that is a non-safety critical operation, as it were.
Indeed, and the judge would, on the judge's construction, it is a safety critical feature. So I can see why you're asking that question.
Yeah.
Having read the judgment,
Yes.
it's absolutely clear from the judgment that the judge would say that that's a non-safety critical feature.
Yeah.
We say it's a non-safety critical feature, and I'm going to develop that in the context of ground one very shortly, indeed.
All right.
But I take your lordship's point on board. Just to give you a preview, you have to find some non-safety critical features. You have to construe the claim in such a, you have to construe the word, the expression safety critical in such a way that, for example, a CGM app will have non-safety critical features. And
Do you really have to? I mean, it's a method for hosting a safety critical app, so surely, at least intuitively, it would seem a bit strange if it didn't apply to an app which only did one thing, which was safety critical. Why is
well,
that
then
not
you
a
could
safety
never
critical
do. But
application?
then you could never do integer 1.2d.
Right. Well, that's because you've got nothing to enable.
Indeed, but 1.2d does require. I'm jumping ahead. May I develop that in a moment? I just
Just before you do so, though, I mean, I do note that the claim isn't about glucose monitoring devices in the way it's
Specifically.
expressed. It's quite general, isn't it?
indeed.
It seems to be any safety critical application.
Absolutely, it absolutely is that wide. When the specification is describing the invention, that's given. It's clear that's the paradigm case, not least because it's an Abbott patent. But yes, absolutely, it's not limited to a CGM device. Oh, excuse me, it's not limited to a CGM app. The limit is in 1.4. So the uncontrolled data processing device being in data communication with at least one of an analyte monitoring device. So a CGM would be an analyte monitoring device. Analyte just means something that you analyze. Or a drug administration device, or a combination of both an analyte monitoring device and a drug administration device. So it's limited to that, but the analyte doesn't have to be blood glucose. And the drug doesn't have to be insulin. But that's the paradigm case. I wanted to mention at this point that EP 223 was the subject of an opposition in the European Patent Office, and the opposition upheld the validity of the patent in an amended form. The amendment's a narrowing amendment, but not in a way which is material to the issues on the appeal. So for reference, the amended form of the claim is in the bundles, and the supplemental bundle, page 194. But the amendment makes no difference to anything that you have to decide. You can work from claim 1, because if you find the claim is granted valid, then obviously the narrower claim is valid. And if you consider that claim 1 as granted is anticipated, then I'm not suggesting that the amendment makes any difference to that. So it's just easier for your lords to work from the version in both of our skeleton arguments, just for convenience and consistency with the judgment below.
So you're telling us that there was proceedings in the Patent Office, the European Patent Office about this, I get that. And there's a decision of the Opposition Division, which is the first instance decision.
Yes.
Is there an appeal?
No,
So that's finished.
that's done. Yes.
So strictly speaking, the patent has been amended.
Yes.
So we're actually not looking at the moment at the words that are in fact the words of the actual granted patent.
No, indeed. But because
You're telling us it doesn't matter.
I am
get
telling you
that.
it doesn't matter. In terms of the reasoning of the opposition division, they said there were multiple reasons why GADOS didn't anticipate claim 1, and they identified 2 of the multiple reasons. Well, making clear they weren't exhaustive. One of those reasons I don't rely on. The other reason corresponds to exactly to my ground 3. So I'm going to show you that reasoning in the appropriate point in my submissions on ground 3.
Okay.
Your lordships, of course, will make your own mind up, but it's appropriate for me to show you what the opposition division said. So as I say, the debate about being safety critical comes into ground one, but I would like to show you the GAIDOS prior art and then develop ground 1, 2 and 3 in that order, if I may. Thank you. So I'm now turning to the GAIDOS prior art. So I'm now on paragraph 48 of our skeleton argument. GAIDOS itself is in the supplemental bundle, tab 4. So this is a US patent application. It's not related to the issues arising when you install an SCA on a UDPD as 223 is. It's aimed at a completely different issue to that addressed by 223. So I'm not going to read the entire patent, but paragraph 1 says that the present invention relates to healthcare-related database systems, and in particular to integrity checks of healthcare-related database systems.
And that's on page 149.
And 149. And an illustration to orientate oneself that's useful is on page 142, figure 3. So item 200 is an ordinary desktop computer, for example, in a GP's office. Item 222 is an old-fashioned BGM, a device for analysing blood that the user has got from their
BGM, blood glucose
monitoring. Which you use the way you use that, as I described. You prick your finger and put the blood on a piece of paper and stick it in the device. So that is an analyte monitoring device. And the idea that's illustrated in figure 3 is that the user brings their device 222 along to their GP's office and uploads the historical blood glucose data, which is stored on the device, to the GP's computer. So 218 is a wireless transfer of data from the BGM to the computer. And then the GP can review the historical data with the patient to see how well they're managing their diabetes. The computer 200 could also be the user's own personal computer in their home for reviewing their data. And what I've just explained to you, you get in particular from paragraphs 28 and 38 of the specification. Can we look at 38, please? Page 152. So in 38 it says, in one embodiment, healthcare management software system 106 is diabetes care software, which is loaded onto a computing device 100. So the desktop computer 200 is an example of a computing device 100. The diabetes care software interacts with a blood glucose meter to receive blood glucose values and other physiological information. The diabetes care software system is then able to present the blood glucose values to the patient or caregiver for review. And then it refers to figure 3. GAIDOS does also say that the computer could be a portable device, but what the desktop we see in figure 3 is, we would say, the paradigm setup. Now, that's the context for GAIDOS. Its contribution is to describe something it calls integrity checks, which we saw mentioned in paragraph 1. And the integrity checks are introduced in paragraphs 2 and 3 on page 149. Please could you read paragraphs 2 and 3? Sorry, I should just tell you that your lordships don't need to get into the details of millimolars per litre and the equation that's shown there. It's the general point that they're making about units of measurement. Now, there's more detail about the integrity checks at paragraphs 43 to 45, and that text is fairly indigestible. At trial, we agreed with Dexcom's expert summary of this text, so I'm going to take his summary as fairly representing the common ground. So that's still in the supplemental bundle behind tab 5 at page 158. So on 158, Dr. Sturbu said at paragraph 126, the invention of GAIDOS relates to medical databases where the units or other information associated with the data may be different, for example, because of different regional configurations. When a device is updated, the data should be correct for the user of that device. The measurement units or any kind of conventions regarding how the data is presented need to be verified to ensure the integrity of the information in the database is maintained. And then at 130 on page 159, GAIDOS describes a method to ensure that the physiological data is stored in a format required by a healthcare software application in the relevant geographical location. The conversions, integrity checks, are performed on importing data, migrations, or on demand. Now, the judge found that GAIDOS anticipated claim 1, and what I'm going to do is, in relation to each ground, address the integer, the relevant text, so far as I've already showed you in the judgment. I should mention that formally, Dexcom also ran an obviousness case, but they didn't really develop that case in closing, as the judge recorded at paragraph 450. And the reality always was, or always should have been, that GAIDOS was an anticipation or nothing case. The reason I'm mentioning obviousness is because during the course of the trial, Dexcom wasn't disciplined in observing the distinction between anticipation and obviousness in its evidence, cross-examination and submissions, and I will be submitting that the judge appears to have fallen into the same error. Just Lordship needs to be alive to the fact that when we look at materials from trial, it may be going to obviousness or it may be going to anticipation. So my client's appeal on 3 grounds corresponding to the 3 reasons that we argued at trial that GAIDOS doesn't anticipate. And again, I only need to succeed on one of these grounds to overturn the finding of anticipation. So ground 1 is the meaning of safety critical application. And that's addressed in our skeleton argument starting on page 28. Now, if we have in mind the introductory section of EP 223, we saw what that said about safety critical systems in 1, 3 and 4. They're the integrated control medical systems. And then the patent went on to talk about safety critical applications at paragraph 5. And what that tells us is that the safety critical applications of paragraph 5 are application versions of the safety critical systems described in 3 to 4. So paragraph 5 is talking about taking something which previously would only have existed in the form of an integrated controlled system and putting that on a UDPD. For example, the reader functionality of a CGM, which at the priority date existed only in the form of those controlled integrated systems that we saw pictures of, and putting the reader functionality on a smartphone, and that obviously was a matter of real interest at the priority date as the judge held. So the SCA of paragraph 5 is not a mere general purpose application of the sort which has already been used in UDPDs in 2009. So a database program, for example, which had been used on UDPDs, such as desktop computers for decades, is obviously not within the contemplation of paragraph 5, nor things like word processing apps or calculator apps, so on.
I'm sorry, Mr. Abrams, I'm not sure what you mean by paragraph 5. Which paragraph of what?
Sorry, of the patent. Paragraph 5 of the patent is contemplating taking something which hitherto had only existed in the form of an integrated controlled system.
Can you give us a page number?
Yes, sorry. So this is the supplemental bundle, page 32, tab 2.
32.
Yeah.
Thank you.
So it's
Okay.
yeah. So as I said, 1, 3 and 4 were describing these safety critical systems that are tightly integrated. The manufacturer has complete control over all the hardware and all the software. And paragraph 5 is saying, well, what happens when we take some of that functionality and put it on a UDPD over which the manufacturer, i.e. the person who writes the software, doesn't have complete control over other software running or hardware of that UDPD.
Yes.
And so what that tells us is that the safety critical application of paragraph 5 is not a general purpose application which, as of 2009, had been running on UDPDs for decades. It's not. In 2009, anybody reading this patent would have a desktop computer and a mobile phone on which there would be word processing software, calculator, database software probably, and other applications that have been on UDPDs for decades. Paragraph 5 is not about that sort of software. It's about software implementing something which previously would only have existed as a tightly controlled integrated safety critical system as described in paragraphs 3 and 4.
So you're saying that when the skilled person reads safety critical application in the patent claim, they're supposed to think about whether that is a version of something that used to exist not in a smartphone, say.
So just to be clear, let me answer that with two points. Firstly, when they read it in the patent claim, they understand it to mean what's been talked about in paragraph 5 and onwards. I'm not saying that to be a safety critical application, there has to be a previous integrated system, and only once the integrated system has been released on the market and then transferred to smartphone form can it be an SCA. I'm not saying that.
Okay.
What I'm saying is it has to be of the nature which, as of around 2009, would be expected to be in a tightly controlled integrated system, but is now being put on a UDPD. So a safety critical application is an application for...
That can't be right, Mr Abrams, if I may say so with respect, because your patent claim is designed to run 20 years into the future, roughly speaking, from when the patent was granted, and it would be intended to be infringed by somebody who came up with a safety critical application 19 years after you,
Yeah.
Which had never been invented before. If it was a safety critical application, it would apply, and it's got nothing to do with whether people used to do it on smartphones or anything else.
Yes, sorry, I obviously wasn't clear. What I was saying is this: the claim is talking about a safety critical application on a UDPD, but paragraphs 3 to 4 tell you that safety critical means critical of a level where hitherto you would expect that to have been implemented in the form of these tightly controlled systems. Now I'm not saying that that's the definition of a safety critical system. I'm not inviting your lordships to define safety critical system in terms of whether it should or could have been in an integrated system described of the type in 3 and 4. What I'm saying is that tells you what safety critical means. It's that level of safety critical. It excludes general purposes applications. And so even, and I think this is, when we come to the judge's construction, this will make more sense. But this text helps you draw the line between really safety critical, which is what the patent is about, and anything which, if it malfunctions, could have some effect on a patient. That's really my submission. Because there is...
Talking about the degrees of safety or
yes,
criticalness or both.
Indeed.
So it's a high degree of safe criticalness because of what you just talked about.
Indeed. If you hadn't read this page, you might think, as the judge appears to have done, well, I can imagine a situation in which a calculator app or a word processing app could be safety critical. And I'm going to develop this submission in a moment. But this text tells you that when they mean safety critical, they mean really safety critical, not just anything which a general purpose application of the sort which has been on UDPD for years might involve. And so as I say, the paradigm case of what is really a safety critical application would be a CGM system, because if the real-time blood glucose reading malfunctions, the user might, for example, take some insulin when not needed, if the number was wrong, or fail to eat some sugar, and that could literally kill them there and then. And that's why I showed you the paragraphs on the effects of hypoglycemia. Okay. The system of GAIDOS doesn't give rise to that sort of safety implication at all. GAIDOS is about a database of historical patient physiological data that's been uploaded from a BGM for review, in particular by medical professionals in clinical settings. It's not designed to be used by patients themselves to make treatment decisions in real time in the way that a CGM is. And as I've said,
I think it
databases...
spoke about carers, didn't it, as well as
Yes,
medical professionals.
that would be a parent,
Yeah.
for example.
So they might not be some clinical specialist. It might just be someone who is interested in monitoring changes in blood sugar.
Yes, remember, of course, the GAIDOS is not monitoring. It's not monitoring the changes in blood sugar.
Sorry, monitoring is the wrong word, but
Managing.
reviewing, for example, spikes
Yes,
or lows in blood sugar, and they might be interested in saying, oh, that happened after some recognisable event like eating or going for a run.
precisely. But on the as to their current blood glucose level, upon which they'll be making decisions as to whether to take insulin or carbohydrates, they're using their BGM, item number 222 in figure 3. So that's the BGM. That's what they would be looking at to see what is their current blood glucose level for the purpose of taking insulin or carbohydrates or something else. And 222 is the controlled integrated system described in paragraphs 3 and 4 of the patent.
So is it really so difficult to imagine that the downloading of some, I mean, historic doesn't mean ancient history, historic it just means today and yesterday, say, blood glucose levels, if it was messed up, which is what the point of the invention in GAIDOS is to do, is to stop you messing it up because the units are all mangled, wouldn't run the risk of a wrong diagnosis or something like that, or wrong advice, which could be pretty significant. Someone might be sent away being told there really isn't a big problem you need to worry about, you're actually controlling your glucose levels very well, when in fact you're not. So it doesn't feel that far-fetched to me. No,
indeed. Your Lordship is putting that is the high point of the case against me on ground 1. Absolutely, and that's the case I have to meet. And we say the following things. First of all, there's obviously a big difference here between the immediate taking of insulin and or carbohydrates, or not taking insulin and not taking carbohydrates, based on a real-time reading, versus historical review and how are we going to manage going forward in a more general sense. More specifically, the problem with that and that approach is that you could imagine a scenario in which a chain of events like the one you're positing leads to an adverse event for the patient with just about any general purpose app. So, for example, a word processor app in which the decimal point key wasn't working could lead to too much insulin being prescribed. We can imagine something similar for the calculator app on a doctor's smartphone. A sat-nav could direct them to the wrong house. Sat-nav wouldn't satisfy one of the later integers of the claim, but if we're talking about safety critical, what the meaning of safety critical is, a sat-nav, if it takes you to the wrong Arcacia Avenue, then that could lead to an adverse event for the patient. You can play this game as a sort of parlour game.
Yes, might it be said that what GAIDOS is talking about and what the patent is talking about is something which is sufficiently critical, where the data is sufficiently critical to safety of a patient, because it's a medical context, and your claim, I think, is limited to medicine,
medical,
because it's analytes drug administration, which was important enough to be worth doing these checks. Isn't that what this is all about?
Yes,
That's the
indeed.
scale of importance you're measuring. Is it important enough to be worth checking?
I agree, absolutely. That's my point. And there's no evidence that this level of checking that's described in the patent has ever been contemplated or suggested for the sort of general purpose applications that I've just made that submission
Well,
about.
but the point that's put against you is it is contemplated in GADOS.
Well, the
It's
integrity,
important enough in GADOS to do an integrity check.
indeed, and then that leads to ground two, whether it's the right sort of check. But yes, on ground one, there's that sort of check, but no one has ever. That's why I suggested that the guide as to where the line is between safety critical and non-safety critical is derived from the distinction in paragraphs 3 and 4 and 5 between safety critical system and then putting that safety critical system in app form on a UDPD, because the database of GADOS is just database software. I mean, it's specific for a particular type of database, but it's just database software, and database software has been used on UDPs for years. They're not the sort of system or application where hitherto has been regarded as something that you would expect to be on a tightly controlled, fully integrated system. It's exactly the sort of system that you would expect to be on a UDPD all along and had been for decades. And that's why I've suggested that as a useful touchstone for drawing the line between really safety critical and, if I might call it, well, I could imagine how something could go wrong if it malfunctioned. Safety critical in that sense.
Okay.
Let me just ask a technical question about the GADOS matter. The idea seems to be to do with a database onto which information is being uploaded in the way you described. Is the idea that it's a database that has information from lots and lots of
Certainly.
patients? Is that how it's conceptualized?
Absolutely.
So that the, as you called it, the paradigm case would be that the doctor has got, or the clinician, maybe a researcher, I don't know, has got, let's stick to this glucose kind of data, has got data about a whole series of different patients, is that right?
Yes.
And from the bits you showed us, it seems to be about making sure that the units are all the same.
Correct.
So that, in other words, so that the doctor can then look at this, is this right? The doctor would be able to then to look at this person's data and say, wow, that's way out of line with expectations or something like that.
You're not managing it well. You're getting wild swings.
Yeah.
You're not. We talked about we saw the tightrope. You're not walking the tightrope nicely.
Right.
You're eating too many sweets, or not enough sweets.
Yeah.
You need to do more exercise. And so on.
Right.
So we do say that the broader approach to safety critical application, which, my lord, you were putting to me, it is too broad because it catches general purpose applications when it's clear that it's not the patent's not intended to do that. Another serious issue with that approach is that the Claim 1 positive, the SCA, includes both safety critical features and non-safety critical features. And on our interpretation, that causes no problem. And I gave the example which works on our interpretation, that the real-time glucose monitoring on a CGM app would be a safety critical feature, and functions such as display of historical data, which all CGMs had at priority date, would be non-safety critical. But on the judge's approach, we can't see what features of a healthcare app could not be classified as safety critical. Review of historical data obviously would be safety critical on that interpretation, because that's what the judge held with regard to GADOS. But so would everything else. And so on the judge's approach, it's impossible to see how there could be selective enablement as required by integer 1.2d in the context of GADOS. And that point will come back to bite the judgment or help me on ground 3 when we get to it.
Does the patent give any examples of a non-safety critical app?
It does
feature,
not.
or whatever the word was, feature, yeah.
It doesn't.
Okay.
It doesn't. I'm doing as I said, 47 and 48 is the level of detail.
Paragraphs 47.
Paragraphs 47 and 48, and I'm just checking my memory, but no. What I can get out of 47 and 48 is that they're written on the assumption not that there might be non-safety critical features, but there will be. So it's assumed that any safety critical application will have non-safety critical features.
Could you have an app which happens to be all safety critical features? And would the claim then be, well, they'll all be switched off, to put it in colloquial terms? Because there aren't any non-critical ones.
So if you had such an app, you could never infringe the patent, because you could never have this, because the claim requires enabling non-safety critical features. And so if such an app existed, then its use would never infringe.
Might a skilled person reading this think that if they were being told that they were required to enable a non-safety critical feature, they give an example of what sort of feature they're supposed to enable, since it doesn't give you much help.
You make a fair point, but all I can go back to is that the patent is absolutely clear that the application of the invention must have non-safety critical features. I think we've done safety critical sufficiently, so I'm going to move on to ground 2, which relates to the integrity check of GADOS and the checks required by Claim 1. So I can do this off my skeleton argument, tab 2, page 30. So, as I mentioned earlier, I'm not pursuing the argument in paragraph 58 of our skeleton argument because we accept the judge's construction of Claim 1 to that extent. However, I am still pursuing the 2 points in paragraphs 57A and B, either of which are sufficient for me to succeed on ground 2. So the point at 57A of our skeleton argument is that the integrity check of GADOS is not an installation check. And we saw that the integrity check disclosed by GADOS comprises a check of the contents of the healthcare database to ensure they're accurate in the sense that the measurements are recorded using the correct units, or at least the units that are expected by the user or the system. That doesn't tell the user whether the system or the database has installed correctly. So, for example, the database might be able to operate so as to display units with the correct data, but a portion of the database file could nevertheless be corrupted because it didn't install properly or at all. That sort of failure to install would not be detected by the integrity check disclosed in GADOS. And so on no view can the integrity check be described as an installation check or a check that it's installed properly. Now, the judge addressed this in his judgment at page 158 of the core bundle. Starting at paragraph 435. So 435 refers to some evidence of Dr. Palleur. Effectively he says he doesn't describe any checks to ensure that it doesn't install correctly. Then all of 436 and 437 relate to the construction of the patent claims. Nowhere does the judge identify any teaching of GADOS which actually anticipates the requirement for an installation check, nor any explanation of how any teaching of GADOS discloses such a check. So it's certainly not clear to us how he came to the conclusion that the integrity check could be described as an installation check.
Well, I just looking at 437, as I understand it, what the judge is saying there, where he says, so EP223's installation check is satisfied by checking an image of a single SCA component, including a database file. As I understand, I may have misunderstood all this, but that to me carries with it a conclusion, a view that to check an image of a single database file, a single component, such as a database file, would be an installation check.
Indeed, but the integrity check is not checking the image of a database file.
Okay. So what is an integrity check?
Sorry?
So what is an integrity check?
Well, it's a check to ensure that the units used in the data of the database file are the units that the system is expecting.
Nathan, where do we get that from? I'm not doubting you, Mr. Abrams,
No.
but it'd be nice to see where we get that.
Yes, so you get that from I referred to it being indigestible. So you get that, the text being indigestible, you get that from paragraphs, the exact numbers. You get that from paragraphs 2, 3, 43, 44 and 45, which I referred you to. I showed you 2 and 3, and I showed you the summary of that disclosure in Dr. Sturbu's evidence.
I know, yes, hang on. 2 and 3, unless I missed it, don't mention integrity.
No, they introduced the concept of the different
I get that.
units.
Yes, so what are the other paragraphs?
43, 44 and 45. And I didn't invite you to read those.
No, you didn't.
I referred you to them and suggested that you take their teaching from Dr. Sturbu's evidence, which is much more digestible.
It says, looking at, it doesn't have line numbers, but looking at 43, about line 6 or 7, a sentence that reads, the integrity test may be any process whereby the accuracy of patient database may be affirmed or denied. That doesn't feel to me as though that is as limited as you just said about units.
Well, if you read on, you see what it's talking about. I mean, that when it says accuracy is that sentence is very broad and doesn't disclose anything as specific as an installation check or a functional check. It's just talking about the accuracy of the contents. I mean, we could have a debate about whether the specific types of check in the patent, the installation check and the functioning check, would fall within that broad language, but that broad language certainly doesn't disclose specifically checking installation or functioning.
Why doesn't it?
Because it's just talking about the accuracy of the contents, and it then goes on to explain what it means by that.
I don't want to give evidence, Mr. Abrams, and I'm just a bit worried that whether there is evidence about this, but at least speaking for myself, if you imagine a computer and there's a block of information, call it a database if you like, and you run a check on it to check that you are, what are the words used there? Whether it's accurate. So you must have an opinion about what it should be, and you check whether it is what it should be. And that's how I'm, and I know this, if I'm giving evidence, I apologise, but that's how I read at the moment what's said in 43 of Gados. And then I look at the judgment, that paragraph that I drew to your attention. It talks about checking an image of a single ... database file. It feels to me, without trying to be an expert, that that's the same thing, isn't it?
With respect, no, my lord. There are two points. One is that I risk of repeating myself. The sentence that you point out in paragraph 43, referring to the accuracy, is extremely broad, and accuracy can be tested in a number of different ways. So there is no clear and unambiguous disclosure of checking installation or indeed checking an image. And secondly, one has to read the whole of this passage together, and that's why I considered it useful to show your lordship what Dr. Sturbu had said, because when you read that passage, that is what although that's a witness giving evidence about what the document says, that is a reasonable understanding of what this passage as a whole is saying. It's saying that the integrity checks are checking the units are the correct units or appropriate units for the region, for the region or the system that you're using. So that sentence on its own is a very broad sentence which could cover all sorts of things which are not clearly and unambiguously disclosed. But the passage as a whole is clear about what particular type of check it's talking about, and that's not an integrity check, that's not an installation check, nor is it a functional check.
Isn't the difficulty that one may or may not be a cause of the other? If you do a test, taking what you're saying, I'm not trying to fence with you, Mr. Abrams, taking what you're saying, what the GADOS document describes is only ever something worrying about units. That was meant to be a relatively fair paraphrase of your case.
Yes, it is.
That could be, and let's say it finds a problem with that. Might that not be due to an imperfect installation?
It might be.
How do we know whether it is or isn't? I don't mean how do we, the computer, know? I mean, how do we in this court know that it is or it isn't?
No, indeed, it's not good enough for the purposes of the claim that the integrity check would be, say, tripped in some situations which are caused by a bad installation. The installation check, what the claim is saying is verifying whether it's installed properly. And if what's happened is that half the data is there, but half the data isn't there, it's just not installed, the integrity check of GADOS will look at the units. If the units are correct and it's all happy, yes, this is all, what I've got is all accurate and fine, I can display this to the user. Then it will display this to the user, and the fact that half of the data hasn't been installed will not be detected by that check.
Evidence for what you're just saying to us.
Well,
What you're saying, as I understand it, is that if you imagine a database, just a load of data, you could, unless you check every single aspect of every single feature, it may have stuff in it which is okay and stuff in it which is not okay, and unless you've checked it all, you have not satisfied the test of and quotes installation check, which I don't remember reading anywhere in the document. But maybe you're right. I'm not saying you're wrong. I'm just trying to understand.
Well, I'm approaching it from the defendant patentee's point of view. There was no evidence that the integrity check would reliably detect failures of installation of that sort. It was the argument was it's broad enough. It didn't. There is a lack of evidence of what would be needed in order to find that this is anticipation.
Right.
I mean, there's no evidence that the integrity check of GADOS would detect installation failures of the sort we're discussing. It's that way around, the lack of evidence.
But that's a different point from the way your appeal is run, isn't it? As I understand your point on appeal, you say that what's described simply doesn't satisfy the construction of the claim.
Yes, it's the result of the way your lordship put it to be that I mentioned the lack of evidence. As you've as the judge records in paragraph 435, Dr. Palerm said GADOS doesn't describe any checks that would this is 435, does not describe any checks on the healthcare management. So 435.
435.
GADOS does not describe any checks on the healthcare management system application to ensure that it installs correctly.
So he then says, as Dexcom submitted, that's Dr.
Yes.
Palerm, which is your witness, yes?
Yes.
Appears to understand that the installation check must involve a check of the software executable.
Yeah, so that's how he. You're right. That's how he then.
That's your case, is it?
No. So that's how the judge sidelined that evidence. But what my point on this limb of ground 2 is that the judge didn't explain how an integrity check could detect failures of installation, where that's disclosed in GADOS.
Okay.
And my lord, we make a very similar point on the other part, functional check. So, for example, if the system was, in response to a request for physiological data of one patient, was fetching the data of another patient, then that wouldn't be detected by the integrity check described in GADOS. And so the integrity check of GADOS, while it's a useful check for the reasons described in GADOS, it is not a check of whether the system is installed correctly or is operating correctly. It's a check of something different. My lord, that brings us on to ground 3.
Okay.
And this is selective enablement. This is addressed in our skeleton argument starting at page 31. And this is the ground that the controller accepts has some force and which the opposition division of the EPO also upheld. So this ground relates to integers 1.2b to d, which specify what happens in the case that one of the checks is failed. And I've made this point already, but just for reference, we summarise what those require in paragraph 59 of our skeleton argument in terms which I understand to be uncontroversial. And that's what we call selective enablement. Now, GADOS contains 5 lines explaining what happens if the integrity test is failed. So that's in the supplemental bundle, tab 4, page 153. So if you've got paragraph 43, in the middle of that paragraph, do you see the reference to figure 5? And then the relevant bit starts on the next line. Quote, the healthcare management software system provides an indication of a non-verified database integrity in response to a failed integrity test, as represented by block 270. An exemplary indication of a non-verified database integrity test is an error message presented by one of the output devices. And then it says, if the healthcare management software system provides an indication of verified database integrity in response to a past integrity test, obviously that's not relevant to selective enablement. So all it says there is that if the integrity test is failed, there can be an error message, and on no view is that a disclosure of selective enablement, nor certainly can it be said that selective enablement is implicit in this text. There are a number of different ways that this could be implemented. One is when the error message is displayed, the whole system could be disabled until it's fixed, or the error message might be dismissible, i.e. the system might allow continued access to the database, leaving the user to take care because the units are not correct, maybe making manual conversions. And one could think of various other ways to implement this, especially with the benefit of hindsight. But there's absolutely no clear and unambiguous disclosure of anything about which features are enabled and which are disabled. So your lordships can see why the controller thinks I have a good point here. Now on top of this, you only reach ground 3 if you're upholding the judge's very wide construction of the expression safety critical. But on that very wide construction, it's difficult, if not impossible, to think what would be the non-safety critical features of the database. None are disclosed in GADOS, and I'll show you in a moment what's said in evidence about that. My lords, the judge addressed this in his judgment at in the core bundle tab 6, page 160. Starting at 445. So 445 refers to some evidence from Dr. Sturbu, that's Dexcom's expert, and I'm going to have to show you that. 446 refers to Dr. Palerme's evidence, and I should show you that as well, which I will do in a moment. And then 447 is a submission from Abbott, and 448, the judge said, I accept Dr. Sturbu's evidence. Now, the first obvious point to make is that the judge nowhere explains what he thinks the non-safety critical features of GAIDOS are, nor where it's disclosed that such features are enabled when the error message of paragraph 43 appears. And that's the point that might be an artifact of the distance in time between the trial and the writing of the judgment. Now, I need to show you Dr. Sturbu's evidence because he at least did deal with the point. So that's in the supplemental bundle behind tab 5, page 162.
160.
162.
Thank you.
So at the top of 162, Dr. Sturbu quotes most of the claims reference to selective enablement, save for the enabling of non-safety critical features. So then in 246, he's addressing the first limb of selective enablement, i.e. the disabling of safety critical features. And then he quotes the second limb of selective enablement, enabling non-safety critical features, and he addresses that in 247. And your lordships will read that, please. So I'll make 3 points about this evidence. First, both paragraphs are written in terms of the skilled person would understand. That's not the same thing as saying that the document would disclose something. That's saying what would occur to the skilled person when reading the document, which obviously isn't part of anticipation. Secondly, 247, as I said, deals with the second limb of selective enablement. And he refers to figure 6 of GAIDOS, which your lordships will find on page 145. It's probably, if it's possible to keep one finger in page 162 and go to page 145 of the supplemental bundle, that would be helpful. So Dr. Sturbu points to items 312, 314 and 316 of figure 6. These are briefly explained in paragraph 48 of GAIDOS, but there's no teaching that these are not safety critical. Remember, on the judge's broad interpretation of safety critical, almost anything can be safety critical feature. For example, advanced reports and letters, 316, that is for communicating things like treatment options to a patient. On the judge's approach, that would make them safety critical, because if you miscommunicated a treat with the patient, that could lead to an adverse event for the patient.
As I understand it, you would agree that these are non-safety critical. You say that what's wrong is the judge's approach to non-safety critical would include them.
Correct. Third, still on paragraph 247, there's absolutely no disclosure that these functions in figure 6 are still usable even if there is an error message per paragraph 43 of GAIDOS. That's the killer point.
Did anyone cross-examine Professor Dr. Sturbu on this paragraph 247?
There isn't relevant cross-examination. This is about anticipation. The judge, of course, didn't grapple with any of this. So we say there's no clear and unambiguous disclosure of a non-safety critical feature, let alone disclosure of such a feature being enabled despite a failed integrity check. So whether these are safety critical or non-safety critical, there's no disclosure.
Just to make sure I've understood you, Mr Abrams, so paragraph 247, the expert says, the skilled person would understand from paragraph so-and-so that these features would be disabled. Sorry, would remain enabled.
Indeed, that's what he says.
And your position is that's not right.
Then, well, if that's talking about we say that's talking about what would occur to the skilled person. That's what he's addressing. It's
So
not. Sorry.
You.
It's not right that they're disclosed. My submission is he's not saying that this is actually disclosed in GADOS, but if that's what he was trying to say, then it just isn't disclosed in GADOS.
Okay. So this is my words, not yours. What you're saying this means, this evidence, is, putting it crudely, you say this evidence is that the skilled person, it would be obvious to a skilled person reading GADOS that you could do this by enabling those two things.
That's what he's trying to say. Yes.
That's what you think. That's what you're saying he's trying to say.
Yep. My Lord, I showed you paragraph 446 of the judgment, which refers to some evidence of Dr. Palerm at trial. Now, I understand that my learned friend and I agree that that evidence isn't relevant to anything you have to decide. And the reason I say that is because he didn't mention this paragraph or this evidence in his skeleton argument, and he didn't ask for the evidence to be included in the appeal bundles. But since the judge mentioned it, I think it's appropriate that I should address it, which means handing up the pages of the relevant pages of the evidence.
Yes. What it's worth, Mr Abrams, I agree with you. I was just about to ask you, can we see Dr. Palerm's evidence? And then
You agree with me that I ought to show it to you?
yes.
Yes.
While that's coming up, can I just go back to paragraph 247?
Thank you. Of
Which this was.
oh, 247 of Dr. Sturbridge, yes.
He uses this phrase, only the features of the healthcare management software related to the database are disabled. So, do you accept that all these other features, like the, I don't know, the administrator functions or whatever it is, no, it's the advanced reports and letters function, is that part of the same app?
Yeah,
Do
yes.
you accept that it is part of the same app?
Yes, for this purpose, yes. For this purpose, so the judge identified the whole system as the application that was an SCA. So yes. So I don't take the point that these aren't features of the app.
Right.
I take the point that firstly they're not non-safety critical if by the time we've got here, and secondly there's no disclosure of them being enabled when there's a failed integrity test.
Is there any evidence of the database bit of it being disabled when there's an error? Test, I was just...
Your Lordship misspoke. You mean disclosure in GADOS?
Yes, sorry, in GADOS.
Yes. No, there isn't. I showed you those 5 lines. All it says is that there is an error message. It's paragraph 43 of GADOS.
So it tells you that there's an error in the database.
Yes.
Is there anything in that learning which says that it is then disabled, so it won't, you can't look at it or something like that?
Dr. Sturboon 246 says that, and I'm paraphrasing Dr. Sturboon now, one way to do it would be to disable access to the database. but that's not disclosed in GADOS. And I made the submission earlier that there are various ways of implementing paragraph 43. One is the error message comes up and the whole system is just, you cannot use the system until you solve the problem. Another way of implementing it is that the error message comes up and you just dismiss it, but you know now, right, this database is using American units, so I just need to make the conversion in my head. All of these are possible ways of implementing it, but we're in the case against me is anticipation, which requires clear and unambiguous disclosure of something falling within the claim, and it's and there's no clear and unambiguous disclosure of anything other than an error message.
And the bit that the judge refers to in paragraph 445 of his judgment is paragraph 246.
Correct.
And he doesn't refer, as far as I can see, to 247.
Correct. You're absolutely right about that.
Sorry, Mr. Raymond, just to make sure I've got this right. You put this as a point on selective disablement. But I'm not criticising the label, but in a sense it's more than that. Your case is there's no disclosure of disablement at all. Never mind selective or not selective.
Absolutely. Absolutely. Yes, that's an artifact. We had this concept of selective enablement.
That's fine.
Yes. Yes.
So in a sense, it might be said there are 2 points. One is whether it teaches any disablement. It might be an obvious thing to do, but it isn't spelled out in GADOS. Is it implicit in GADOS? Well, there's a question. But you say it's not.
Clearly not.
And then another question is, even if it discloses disablement, it doesn't also disclose enablement of other things while disabling parts.
I absolutely am taking both those points, yes. And I'm right about both those points. I was showing you Palerm 2, so this is Dr. Palerm's second report.
This is the thing you've handed up.
I've handed that up, and I've just, you've got the front page, and you've got the relevant parts of paragraphs 9.2 and 9.3. You can ignore everything except for 9.2 and 9.3. And this is the evidence referred to in the judgment 446. So
you're going to be like
yeah, you've obviously got a lot of questions. So you'll have seen this, the last third or so of paragraph 9.2 is the bit that the judge paraphrases in 446. Now, the first thing we say is that that part is not describing any disclosure in GADOS. That's describing a practical implication of GADOS in light of the CGK. I said earlier that Dexcom blurred the line, failed to exercise discipline between anticipation and obviousness, and it could be said that this paragraph doesn't clearly distinguish between anticipation and the obviousness case. But it's absolutely clear that what is described in the last third of paragraph 9.2 is not something which is disclosed in GADOS. Second, what Dr. Palerm is saying here is that the healthcare management system is not checked at all for installation or functionality. All that's checked is the database, which is a repository of information accessed by the application software. So his point was that none of the features of the system, critical or non-critical, would be disabled. So he's saying there's no selective enablement for that reason. Now, the judge, as we just discussed a moment ago, the judge construed the application as being the whole system, including the database. But Dr. Palerm is approaching matters in that way, and that's why he's saying there's no selective enablement. The third point is that if you accept, well, no, my note says if you accept the judge's construction, whatever construction of safety critical you adopt, this implementation doesn't involve selective enablement. So on the judge's construction of safety critical, then in this implementation, there are no non-safety critical features at all, let alone non-safety critical features that would be enabled even if an integrity check is failed. So on the judge's construction, the continued ability to access the other databases is a safety critical feature. So we would say that whoever's right on the meaning of safety critical, this implementation doesn't disable safety critical features. But and equally on the judge's construction of safety critical, this doesn't involve the second limb of selective enablement. But that's getting into the weeds, as it were. The key point is that none of this is disclosed in GADOS.
This is your witness.
Yes, but this is our witness describing what would be a practical way of implementing GADOS. And as I say, the case was the obviousness case was run in the evidence, and this is responding to that and saying this is how it would work practically. But of course, as we've seen, none of this is disclosed in GADOS. This is simply one practical implementation which Dr. Palerm put forward as.
So I'm just looking at the bit of this start where it says there's a sentence at the lower hole punch that starts the healthcare management system. Okay?
Yes.
Now, putting to one side the question of whether this is describing what's disclosed or what's obvious.
Yes.
What it says, as I read it, is the healthcare management system will have already launched and will continue running even when the database integrity check has failed.
Indeed.
So there's a system, healthcare management system, and it'll keep going even when the database integrity check has failed. And never mind whether a database integrity check is or isn't an installation of functional check. And then it says the only consequence of a failed check will be that a particular database cannot be viewed on the healthcare management software, i.e. a particular file will not be accessible, but the underlying program will still be running and available.
Yeah.
So as I read that, what's being described here by the witness is a scheme in which something stops and something continues.
Yes, at that level of generality, yes.
Or putting it in the language of the claim, something is disabled, something is, dare I say, not disabled, or you might say enabled.
Yes.
Is that right?
The words your lordship has used are correct, yes.
Okay. So why is that not a description of what's required by your claim in relation to the language we're focusing on, not worrying about the other parts of it?
Right.
Why is this not selective enablement?
On the judges, well, no, whatever the answer depends in part on how you construe safety critical, and that's why I have to answer in two parts.
Well, that's why I deliberately didn't ask you that question.
Yes.
I'm deliberately focusing on just this, because frankly, Mr. Abrams, to my own little way of thinking, this looks a lot like something I would describe as selective enablement of something.
So the other databases are still accessible, and what he's saying.
It says a particular database cannot be viewed, but the underlying program will still be running and available to access databases which have not failed to
Yes.
check. Right.
So
Okay, yep. So one database not available, other database available.
right. So the ability to access the database feature is not disabled. It's just that database. It's not we would say that's not a feature that's disabled. That's just that access to that data file is not available.
Right.
Secondly, if I'm wrong about that, if access to that database is a safety critical feature that is disabled, then the ability to access other databases is also a safety critical feature. So the very highest the point could be put is that this is describing disabling of some safety critical features, but enabling of other safety critical features. It's not describing enabling of non-safety critical features, nor is it describing disablement of all the safety critical features.
Does your claim require
Indeed, I
disabling
would say
all
any.
safety critical
We
features,
haven't got
even
into
if
that,
the
but-
only one that failed was one of them?
Well, it's, as I say, that they're either all safety critical or none of them are safety critical.
All right.
So it's not disabling critical and enabling non-critical. They're all,
Well,
They're all
you
equally
say they're
critical.
all one or the other, I get
yeah.
that. This is it fair to you to say that this is a selective enablement of something?
Well, not really, because it's not what because the claim is very specific. Only because the claim is very specific. If we weren't arguing about a claim and we weren't talking about context selective enablement, I can see why you would say it's selective enablement of some databases and not another.
Okay.
But that would be to use the language in a very different way to the way that the claim is using it.
And then my other question, I don't know if anyone else have any questions, but my other question is, and again, candidly, Mr. Abrams, it's not jumping off the page at me that the evidence the witness is giving here is about what would be obvious to do over the document as opposed to what the document describes. And I'm using deliberately the word the witness used.
Indeed. No, you're right, and that's why I started. That's why I said some time ago that there was a lack of discipline, and I accept that this also shows a lack of discipline. But in a sense, you only have to look at paragraph 43 of GADOS to see that on no possible view could this be describing the disclosure of the document as opposed to an implementation.
Okay.
And ultimately, and this is the point that we're going to, in fact, this is the point that we're going to come to now. But in summary, ultimately, construction is a matter for the court. So the court's got to understand clothe itself in the CGK and so forth. But to the extent that a witness is saying this is what the document says, apart from technical terms aside, then it is a matter for the court and not for the witness. What the witness can say is this is how, or this is one way or the way that a skilled person using their CGK would choose to implement this practically for the purposes of obviousness. So it's if this paragraph said, bearing in mind strictly the distinction between disclosure and obviousness, this is what it discloses, it would still nevertheless be a matter for the court to decide whether that's what is disclosed by the document or not, and not for
It's
the
not as
witness.
simple as that, is it? If I remember the law right for this question, construction is always a matter for the court. But if you're asking the question whether what is described in a prior document leads to a lack of novelty, one of the questions is what does the skilled person do? How would they put it into practice? What would they do? What does it disclose, in other words, as a matter of fact? And that is a matter of evidence, and it is relevant to novelty.
If the evidence is this is inevitably the only way that it can be put into effect, then yes, that would be evidence for a witness. This evidence certainly doesn't say that, and I mean, one couldn't possibly say that this is the only way of implementing paragraph 43 of GADOS. Dr. Barron raised this point in his skeleton argument as a point that could be raised in relation to Dr. Sturbury's evidence. And I was going to make the following submissions.
Sorry, just before you do that, just sticking with this evidence for a minute. Just two questions. First, supposing you get two experts and they say, wherever you've got a sort of error, an error message or whatever it's called, on a system like that, the effect of it is that you can't access that database. So supposing that both experts come to court and say that is what having an error message like that actually means, isn't that a bit of technical knowledge which is then informing the court in the interpretation? So the court then says, oh, well, I've been told by experts on both sides that an error message inevitably means that you can't look at the database.
Yes, so
That
it's
would be admissible, wouldn't it?
yes, and the key word that your lordship said was inevitably.
Well, he says the only consequence of a failed check will be, he doesn't suggest there's any doubt about it.
No, but what I'm submitting is that he's not there saying that this is inevitably how GADOS has to be implemented. And the main reason I'm saying that is because he can't possibly be saying that, because GADOS doesn't say anything about this at all. He can only be talking sensibly about a practical implementation of GADOS.
Right. And my second question was that he talks about the healthcare management system will already have launched. And I think you've accepted that the healthcare management system here includes those bits which the judge, which were referred to by Dr. Stuart-Smith and the judge referred to. Actually, the judge didn't refer to it because he didn't pick up that paragraph, I think. But for example, the letters function that we saw referred to in that bit of a disclosure.
Yes, that's part of the system.
That's all part of what the witness is here referring to as the healthcare management system.
Indeed.
Which he says will already have launched and continue running, even when the database integrity check has failed. So that still goes.
Indeed. Same answer. This is a practical implementation rather than what's described in the document.
As I read the evidence, what the judge is doing, sorry, not the evidence, forgive me, the judgment, what the judge is doing in those paragraphs is he sees that Dr. Stuart-Smith is giving evidence that says that a statement in the patent that there's an error message will be understood by a skilled reader to include disabling the safety critical database that has failed. Palermo, and I'm paraphrasing, says the same thing, and also makes Palermo, big Dr. Palermo's pardon, says the same thing, but also adds that there's other functionality which remains active. The point that the judge summarised that was being made by your clients was that one database wouldn't be accessible, but the others might be available to be accessed. But you were saying that that wasn't enablement of non-safety critical features while disabling safety critical features, and he accepts Dr. Stuart-Smith's evidence that it is disabling a safety critical database. And since there doesn't seem to be a dispute that there are some bits which are left on and other bits turned off, the claim is satisfied.
Well, I would suggest that's. I understand. I would suggest that's reading quite a lot into this. Your lordship is that's a very beneficial reading of the claim. He says I accept Dr. Stuart-Smith's evidence. He's not referring to any evidence from Dr. Stuart-Smith dealing with the second limb, and nor does he say that he accepts Dr. Palermo's evidence. So I don't accept that he has in mind the second limb of selective enablement, because he would have identified what the non-safety critical functionality is. Remember, he has construed safety critical in a way that covers looking at historical databases. So when he says other functionality of the application remains active, he has to identify not just other. It's not enough that there's other functionality that's would remain active. There has to be non-safety critical functionality that remains active, and he's not identified what the functionality is or why that's not safety critical.
What about the admin bits and the letter bit?
Yes, well, maybe he has that in mind. He hasn't referred to that bit of evidence.
The witness seems to have had that.
The witness has, but the judge hasn't referred to that. But more importantly, the judge hasn't explained why that's non-safety critical on his approach. There are a number of reasons why we say that he can't have had that in mind, but the fact that he hasn't attempted to explain why that functionality is non-safety critical is, in my submission, puts beyond doubt that he didn't have this point in mind.
Okay.
My lord, just on the point about the role of evidence, we suggest that the most correct statement of the law is the one quoted by my learned friend in his skeleton. We can just take it from his skeleton argument, page 37 of the core bundle. Paragraph 19. So just picking up a point that my lord made to me, it's always, evidence is always admissible on the question of technical terms that are not in normal use, but there are no such terms in the 5 lives of paragraph 43 that we're referring to. If the witness had said, well, error message in this field always carries with it the following consequences, then that would be evidence that the term error message has a particular technical meaning, and that would obviously be admissible evidence. But there was no evidence of that sort, and I mean this is something that judges have sufficient knowledge of, that error messages in computer systems come in all flavours. There are error messages which just shut the whole system down, and error messages which you click on and they go away. And nobody was suggesting that the court needed special guidance as to what an error message was, or what GADOS meant by error message. So,
I mean, actually, I think this is right, isn't it? That although we've all talked about error message, I think it's supplemental bundle 143, yes, which is actually where the closest you get to what this thing is in this chart. And it's the box, I think, 270, isn't it? Because that's referred to in paragraph 43 of the document. It says
270.
Represented by...
Provide an indication of non-verified database
that seems
integrity.
To be what is meant by,
yes,
what we've been talking about by error message.
Indeed, the text...
Indication of non-verified database integrity.
Yes, the text uses error messages. In fact, it gives it as an example. In paragraph 43,
yeah,
it refers to block 270, which is the one that my lord has pointed out. And it says that an exemplary indication, i.e. an example, would be an error message. I suppose another example would be a beep. So an error message is disclosed. So I accept an error message is disclosed in the relevant sense. We're talking in paragraph 43. I think it's the 14th line of paragraph 43. It refers to an error message.
So I'm now confused, because you've got the document at 43 refers to figure 5 and item 270, but item 270 is on figure 4.
Yes. Yes. Well,
that seems to be the detail of the integrity test. Figure 4 is a general description of what happens. The form integrity test is the little diamond in the middle of figure 4. And the outcome 270 is provide indication of non-verified database integrity. And am I right that figure 5 is essentially what's going on inside that diamond 268? Is that right?
Yes. Well, some of it is reproduced. So, for example, block 282 of figure 5. I know you saw you load them. So, almost. You've got 264 of figure 4 has load integrity information, and 296 figure 5 is also has load integrity information. But that's the general idea, that it's providing particulars of the integrity test. And the failed test 292 corresponds to block 270 in figure 4, as you say. So and so block 270 in figure 4 says provide an indication, and the example given in the text in paragraph 43 is an error message. But that really is it. And the additional detail given in the evidence of Dr. Sturbu and Dr. Palerm cannot on any view be described as the disclosure of the document as opposed to an implementation of the document in implementation. And one way, and I would go further and say one way to implement it. Because the court is well able to see for itself that those are not the only way of implementing, quote, an error message, unquote. I'm just because it's the last point I've got on this, but I know I've already said it. I mean, at the end of the day, no matter what any witness had said, this is a case which is clear enough that the court can see that this isn't disclosed, and no amount of evidence from a witness saying that something is there that isn't there would turn words or disclosure that isn't there into disclosure that isn't in the document. So, my lords, finally I was going to show you the relevant part of the EPO decision. So this is in the supplementary bundle, tab 8. And just by way of background, the opposition division first considered the claim as granted and decided that it was anticipated by a document which it referred to as D2. The D2 document is very closely related to the Labelle prior art, which was an issue at a trial. The trial judge held quite rightly that Labelle not only didn't anticipate, but nor did it render claim on obvious. But the EPO thought that Labelle anticipated claim 1 as granted. So it then went to consider the slightly amended claim, and that starts on page 223 of the bundle. Page 227 of the bundle. There's a heading auxiliary request 15, which refers to the amended version of the claim. And then at 28.1, it considers novelty versus this D2 document and says it's novel over that D2 document, obviously correct about that. And then 28.2 is novelty vis-a-vis D1, and D1 is our GADOS document. So section 28.2 is the relevant section, and as you can see from the top of 228, D1 is concerned with the integrity of a database in the context of computerized healthcare management system. The first point that they make, this is the large paragraph, the third paragraph on 228, is about a wireless device. That's not a point that we ran at trial, so I'm not running it on this appeal. Then the final paragraph of this section, beginning, the mapping of the remaining features is similarly unconvincing. For example, the example is the opponents rely for the disclosure of features 1.3 and 1.4, that is selective enablement, on the error message after a failed integrity test of the database in D1, paragraph 43, which is obviously the text that we've looked at. However, the opposition division does not at all see the features of, quote, preventing ... here. So they're just saying, we don't see what I am calling selective enablement in paragraph 43. And of course, there's no one else has pointed to any other disclosure of GADOS other than paragraph 43 as being relevant.
Yes.
Excuse me?
That's fine. Yeah, paragraph 43 there is the paragraph that's 43 with the brackets and the 2 zeros.
Yes,
Okay,
and 1.3 and 1.4 is selective enablement, and you get that because they refer to the paragraph beginning preventing ... and that is the paragraph that contains what we are calling selective enablement. So they say multiple features of the claim are not disclosed, but that's the one example they give. With immaculate timing, entirely deliberately, I finish. Perhaps if I could just check over the short adjournment whether I've got anything else that I need to cover, but
I think we'll let you do that, Mr. Raven.
thank you.
2 o'clock.
I wouldn't want to filibuster just for that purpose.
2 o'clock.
All rise if able.